Hey there, welcome to another news. My name is Matt Margolis.
And I'm Lauren Weldon. We are Margolis Weldon. We are an elder law and estate planning firm in Park Ridge, and we help people protect what they value most. The goal of this presentation is to share some information with our viewership that we feel would be timely and important.
And today we are talking with our friend and colleague Robert Tomei, a partner with JTLG LLC, a full service law firm in Libertyville, Illinois. Robert has been practicing law since 2012 with a focus on consumer rights, foreclosure defense, debt defense, real estate transactions, and litigation. Robert's continued to practice consumer rights law, representing consumers in various business-related disputes with major car dealerships, manufacturers, corporate entities, and financial institutions in both state and federal court. Robert is now focusing on the passion that got him into the practice of law in the first place, civil rights law. He has represented individuals in cases involving Title VII discrimination, First Amendment, statutory due process, as well as constitutional due process related claims. Robert's married to his wife, Catherine, and they have two young children, Aviana and Santino.
Aviana.
Aviana.
Santino, you got it.
Sorry about that.
All right, Robert.
It's tricky. That one's tricky. It's like Ariana, like the singer, but with the V. And more often than not, we get Aviana. But yeah.
Oh,
Cute names.
nice,
I like
nice. Yeah. So, Robert, we've got some questions for you. The first one, what happens if I buy a certified pre-owned car and I bring it home, drive it off the lot, I'm really happy, and then I get back to my house and I realize this thing's got all sorts of problems? Do I have any recourse against the dealer?
Yeah, so that's an interesting question, Lauren, because I think a lot of people, when they're looking for a specific type of car, maybe to buy a new car these days, especially with inflation, it's going to be challenging to justify the expense. And so in order to offset the new cost value that you're looking to prospectively take on, you look for a comparable car, maybe a year or two older, with a few thousand miles, that's certified pre-owned, certified by the manufacturer. And the idea here is, and the way that the manufacturers will sell it is 100 point, 150, 200 point check inspection to make sure that your car is absolutely up to snuff, meets all of our certified pre-owned vehicle specifications. We've had techs go over the vehicle ad nauseum, and we certify that this car is certifiable under our certified pre-owned used program. The issue becomes when they're just going through the motions. That certification process, in many instances, you got to check. They're not going through the car as carefully as they should, and as a result, if you end up off the lot with that vehicle and you come to find that there's an issue with the frame, there's an issue with the transmission, there's an issue with body work done to the vehicle, which serves as potential evidence of the vehicle being in a prior collision. All of these are evidence that the vehicle was not certifiable, and you can very often go and get the certified pre-owned checklist and find during discovery they may not necessarily give it to you, and they're supposed to give it to you when you walk off the lot, the actual document they checked through, but you'll see there that they're supposed to check those kinds of things. And when they didn't, when there is a problem with the vehicle, you bring it to the attention of the dealership, and they should do something for you if they're going to value their customer base. Oftentimes they ignore you. They won't respond. Do you have a claim against just the dealer? Yes, but also you have a claim against the manufacturer, because the certified pre-owned vehicle program is a manufacturer's program. So this dovetails into some of the other issues that I often see in these consumer disputes is, what forum are you going to bring your case into? And sometimes you can avoid being pigeonholed into taking your case into a certain forum, which I'll probably address here in a little bit, by just going after the manufacturer, not going after the dealer.
Interesting.
It's good to know. I mean, the concept of a certified pre-owned certainly gives, the consumer some, comfort that they are getting a car that is supposed to be safe and reliable and all of those things. And if it turns out that's not the case, it's nice to know that there's at least some recourse that they can pursue.
then you're paying a premium for that certified used vehicle. You know, you're paying extra for it because you expect to be perfect to the extent it can be as a used vehicle.
Now, sort of on similar but a little bit of a different topic there. You know, the sort of the idea of a lemon, and I feel like my wife, every time I have like an issue with my car, I feel like when I bought my last new car, every time a new issue came up, my wife was like, "You've got a lemon," and I'm like, "Easy, that's not the case, right? You need more than that." Um, but Robert, maybe you can give everybody an idea here, and I can have my wife watch this so she can have an idea as to have a lemon actually. Maybe you can describe what a lemon actually is, and so people sort of have an idea of how that's defined. And then if somebody buys a lemon and they realize they have a lemon and the dealer isn't helping and the warrantor is denying coverage, you know, what can a consumer do? You know, what are their next steps?
Yeah, that's a good question, Matt. And so the definition of what a lemon is, I think in the colloquial sense, everybody understands I have a lemon is a vehicle that is unmerchantable, meaning it's not working according to how it's supposed to work. I bought this vehicle to serve a very specific purpose, and it is not serving that purpose because it's defective in one way, shape, or form. That's a lemon. The way the term is used legally, at least in the state of Illinois, other states are different. You have an actual lemon statute in Illinois. Only applies to new cars though. So when people say lemon, you could buy that certified used vehicle. It's not a lemon under the statutory interpretation under the Illinois code because it's not a new car. So to a new car, the lemon statute of Illinois allows you to bring the car back to the dealer, give them opportunities to remediate the defect. And if they're unable to do so, they're supposed to buy back the car and give you your money back. But that has to take place within the first 12 months of ownership or 12,000 miles, whichever comes first. Also, if the dealer manufacturer, they don't actually do what is required of them under the statute, the Illinois law really doesn't have teeth. And what I mean by that, it doesn't have a fee shifting provision. So if you actually brought a lawsuit under the Illinois lemon statute, you wouldn't be entitled to recover fees and costs. And when you're talking about a vehicle that may have a defect, and if you have an expert opine that the diminished value, the value of the vehicle you thought you bought versus the value of the vehicle that you ended up with is like 10 grand, that's the measure of your damages, how you've been harmed financially. You can imagine if you're not going to recover attorney's fees, you're paying somebody $300, $400 an hour, cost benefit is not there. You know, it's hard to justify bringing a lawsuit. So that's the Illinois lemon statute. Thankfully, Congress saw fit a number of years ago, decades ago, really, to pass the Federal Magnuson-Moss Warranty Act. And this statute applies to all movable goods. It does have a fee shifting provision, so it has the teeth for enforcement purposes. And it's not limited to 12,000 miles in vehicles or 1 year after purchase. It's what does the contract say? What you bought this vehicle with the manufacturer's warranty? What does the manufacturer's warranty say? Is it still within the warranty? Have you done anything to void out the warranty? What is the basis that the insurer, because that's really what it is a warranty. You're buying insurance, essentially you're paying a premium for that additional coverage in the event there's a defect, a manufacturer's defect that they're going to fix. If they don't cover it, they're likely pointing at an exclusion, saying, well, you illegally modified the vehicle, it's outside of warranty, you misused and abused the vehicle. So like any insurance policy, that's the first thing they're going to look for. How can we avoid having to pay for this? I've had many cases in this kind of arena. One recently against a luxury manufacturer, and it's a case similar. The measured damages is 10 grand or thereabouts. We filed a case because my guys brought his vehicle in 7 times. They are unable to fix the issue. So we brought suit. They hire a lawyer who introduces himself to me with a litigation bomb. And what I mean by that is instead of saying, what's your settlement demand? He sends me a motion to dismiss. He sends me discovery requests, a notice of deposition, a notice for inspection of the vehicle. And then he expects that we respond to discovery within 28 days on the mark. Then after we get through all that, he's like, give me a settlement demand. Well, lo and behold, the fee shifting provision, we're keeping track of our time. Settlement demand contemplates the attorney's fees that have accrued. And he says, I can't settle this case now the attorney's fees exploded, which is another issue with these kinds of cases. You have attorneys on the other side who engage in what's called the Stalingrad defense. They dig their heels in, and then they complain about the proliferation of fees on the plaintiff's side. But so long story short, you do have recourse in that circumstance. You have a very powerful federal statute that allows you to have some recourse.
Okay. Wow, these sound complicated, to put it mildly.
How
it can be.
Do you have any? I mean, couple quick follow-up questions. I mean, the average length of a lemon case, start to finish, and as far as the ones that you've worked on or in your experience, how successful are people normally with that have a good case?
Yeah, I'd say because going back to cost benefit, attorney's fees, how are attorneys paid in these cases? Because it's cost prohibitive for a consumer to pay for an attorney out of pocket in a traditional security retainer basis, where you're replenishing every month as fees accrue. We do these on a hybrid fee shifting contingency. You give us a deposit up front, we run with it from there. You carry expenses as we go on. So there's risk for plaintiff's counsel to take these cases. So they need to be evaluated accordingly. So the degree of success, of course, you can't win them all, right? But if we're going to go to court and we're gonna roll the dice on our time dealing with attorneys engaging in that Stalingrad defense, we're usually pretty confident that we're going to prevail, and we do. And in terms of length of time, it just kind of depends. Who's the defendant? Who's defendant's counsel? How quickly are we able to file the case? What's our litigation docket look like? But it can reasonably take, from filing to conclusion, 18 months. Sometimes they don't settle until pre-trial.
Yeah.
So it seems like the contract is a big piece of this, right? So I heard you say a little while ago that a lot of it depends, at least in terms of the federal statute, what the contract terms are and whether or not you voided any of the warranties. Is this kind of like a take it or leave it thing with the dealership, or is there any negotiation wiggle room for a buyer?
Yeah, that's a good question, Lauren. So I'm embarrassed to admit, and I will, even though this is being recorded, and there will be some people that see this, that when I go car shopping, I don't like car shopping. I do it online. I find what I'm looking for, the year, make, model, and then I go shopping and I have people bidding against each other until I get the terms that I'm looking for. Then I'll go in and talk and maybe talk about the trade-in. I try to hide that in my back pocket. But then the idea is you're negotiating the purchase price of the vehicle. Everybody does that. I think for the most part, most people don't just pay sticker price. But some people do. Some people like say, well, hey, I can't do anything for you. The dealer's, comments. They're looking for people to be susceptible to that kind of deception, because there is something they can do about that. You can always negotiate the purchase price. And when it comes to going to the dealership, they want to pair you with their financier because they get additional commissions, and they have an incentive to get you locked into a retail installment contract with the highest interest rate possible. So it behooves the consumer to go in with a baseline. What does your lender offer in terms of interest rates? They have to beat that. Don't go in without having an interest rate baseline. And the other thing in terms of the terms, of course, the manufacturer's warranty is the manufacturer's warranty. You're not going to do anything about that. You're buying it from the dealer, and the argument is the dealer is an agent of the manufacturer. But when it comes to the boilerplate terms in the bill of sale, the retail installment contract, and some of the other provisos that you're asked to agree to, the only one I've really had much success giving pushback on is the arbitration provision. And so there's a separate document where the dealer will ask that if you have a dispute with me, about this transaction, you agree to arbitrate your case in private arbitration. You agree that you are prohibited from taking your case to court. You cannot have your case tried before a judge or a jury. You have to bring your case into a closet kangaroo courtroom with an arbitrator. And usually these people are retired judges. And for the most part, it's fair, but you get limited discovery. You can't do depositions, and it's tough as a consumer to go in that forum. And so we don't like those. We want to have the full weight of the judicial process behind you as a consumer plaintiff to carry forward in the prosecution of your case. So do not sign arbitration agreements. If the dealer says this is compulsory, I will not sell the car to you, you're like, okay, see you later. course, if that's 3-4 hours down the road after you've negotiated, you've test drove the car, they have you sweat, you get the gut cost of I've been here for so long, I just want to sign these damn papers and get out of here. That's a tactic. You gotta accept the fact that may not necessarily be the wisest thing to do, and that you may need to walk away. And that's the only way that you're able to negotiate away provisions like that. And that's really the only one that I think you might have success with getting away from if you're a consumer. I've agreed to it under the circumstances that I just described in transactions from time to time. I'm just, fine. Arbitration, fine. Don't do it though. Don't do it.
Yeah, it's a good general rule of thumb. Don't sign arbitration agreements.
We tell our clients the same thing pretty regularly.
Yeah.
Well, this information was great, Robert. I mean, I think that listen, at the end of the day, people, whoever's watching this, people buy cars, right? People are buying cars. Hopefully, people are starting to buy more cars. I think cars are becoming a little bit more available these days. For the last couple of years, I know they were kind of hard to come by.
Yeah.
Especially, I think I don't know if it was new or used, they were hard to come by. So, really helpful information. I would definitely urge anybody that's watching this, if you do have an issue with a car or any kind of vehicle, to reach out to Robert. Great attorney, great advice here. We appreciate your time and you spending a little bit with us today. And so for all of you watching, thanks for checking in with us, and see you next time for some other news.
All right, guys. Thank you.